So this is chapter 18, performance and discharge. This chapter had a lot of stuff, but I feel like it was easily understandable and pretty to the point. So it talked mostly about discharge. I felt like, which is the most common way for contractual duties uh, which is to discharge by performance of these duties. So first, there's some definitions like condition, which is the qualification in the contract based on the future. So like what you have to do, what duties you have to perform. And then there's like the condition precedent, which is what must be fulfilled before a party's performance can be required. So the precedent, the subsequent condition, and the concurrent condition are three different types of conditions. The precedent, what I just said. Subsequent is it terminates party's absolute promise to perform. So this follows the time which the duty is performed. So in the book, he used an example of a lawyer that would be hired by a law firm if he passed the bar exam, but if he didn't, then he wasn't going to get the job. So that would be an example of that. And a concurrent condition is condition on other parties' performance. So both parties have to do their performance. So like if you order a pizza, then if the person delivers it, then you'll pay them. So you'll pay for the delivery. These can be expressed or implied. So those are pretty straightforward. Expressed is like the parties' agreement, and that can be written or spoken, and that's why it's expressed. And implied is just if it's implied in the contract, if both parties understand. It doesn't have to be written or spoken. And so it also went into a lot of different types of discharge. So it would be like there were so many different kinds. So actually, no, it went into different types of performance. So there was complete performance, which is the whole contract's been performed completely, obviously, no question in that. And there's substantial performance. And so if one party does complete performance and the other doesn't, then they can sue. Satisfaction is another part of performance that both parties must be satisfied with what they have done. Otherwise, the court can get involved. And last, there's also a breach of contract, which is when someone doesn't do their performance, then obviously they didn't fulfill the contract. And then next is all the discharges. There's so many types. So first is the anticipatory preparation. I can't even read my notes. But whatever party may refuse performance if it's not started. So if no one's started any part of their contract, they can say, hey, I'm going to back out if nothing has begun. Also, if there's no time implied on the contract or nothing, then a reasonable time is implied. This, I think, was used by an example was Garth Brooks, how he donated a bunch of money because his mom died to a hospital, $500K or something. And then it was like a few years passed and nothing happened. And so he's like, what are you doing? And they said, hey, we're going to do it in a different way. And then it was just like everything got jumbled and Garth Brooks ended up suing. Also, there's discharge by agreement. So both parties come together and they're like, hey, this isn't going to work. And they agree to just discharge the contract. There's also a settlement, which is just a new contract. Accord and satisfaction, which is to perform the existing contractual duty, and it's all about like the performance and both parties being satisfied. Also, there's operation of law, alteration, which this is how one can be discharged if one party alters the contract without the other party's consent. Then that means that obviously the other party, if it's not involved and they do something that the other party doesn't want, then the contract can be Dust LJ. And bankruptcy, if one party goes bankrupt, then obviously they can't perform the contract or the condition. And so then they make an agreement that the other party gets their assets, so they have to pay them off somehow. Maybe they had collateral. There's also impossibility of performance, which is pretty much they are not able to carry out whatever they agreed to, which also goes along with commercial impracticability. And so that's like if it's too expensive or too difficult, but that's usually if you make the contract and then in the future it becomes difficult, which could be something which is really evident right now with the coronavirus and everything. With like if you promise to do something but now you're not able to work, which also goes along with frustration of purpose, which I'm sure a lot of people are pretty frustrated right now with a lot of the stuff that is going on. So I feel like this chapter was, especially at the end, was super applicable to what's going on in our world today.